have 1 hour and 45 minutes assigned to us. So we are recording this session, I see already, and I suggest we use no more than 15 minutes per person. And I believe you should be able to share your slides. So if anyone has slides that you want to share, please go ahead and share those with us. So my goal here will be to keep track of time, of course, and I believe you can use chat function to send me your questions, or we can just raise your hand at the end of this presentation to pose any questions. The only suggestion I have in terms of organizing, one of our colleagues is coming from Australia, so because of the time difference, we would like Wendy, yes, hello Wendy, go first, and maybe let's ask her questions right after her presentation. And then for the remaining 4 papers, I suggest we leave all questions for the end. And so we will have about 15 minutes for these questions. I think this is all. So Wendy, the floor is yours. Please go ahead, and good luck, everyone.
Hi, good morning, afternoon, and evening to everybody. Yes, I am coming in from Australia, so it's, as you can tell from my lighting, it's quite dark. I'm trying to share my screen, but it says that the host has disabled the participant screen sharing.
Yeah, Antonia, is it something that we can adjust or?
Sorry, Vera?
Yes, we were asking, is there any way we can allow our participants to share their screens?
Yes, I think they, or you can make them host and then they can give back the host to you.
Yes, you will have to teach me this. I'm probably the only person now who is not using Zoom. So what do I do to make them host?
Okay, click on the list of participants and on the name of Wendy.
I do this. Okay, make host. I see this. Okay, just a second, guys. All right, make host. Wonderful. So, yes.
Okay.
Now you should be able then.
Thank you very much. So there we go. So yes, again, thanks to the organizing committee for putting together this conference in, these rather challenging times, and to everybody for accommodating my request to present first. I really do appreciate it. So today, I want to talk about ASEAN and the global development of competition law, and in particular, the narrative of convergence that underlies it. Now, since the 1990s, there has been a rapid growth in the number of competition laws around the world. Prior to 1990, there were only about 20-something competition laws in effect. Now we have over 130. Now, one of the most striking features of this proliferation of competition laws has been the soft, voluntary convergence of all the national laws. Many national and regional competition laws are broadly similar, as they address 3 broad categories of anti-competitive conduct, and they use similar language, standards, and analytical tools. And convergence has occurred even though the countries in which competition laws exist vary widely in their context, and there are no formal competition rules that apply globally. This convergence of competition law is not a coincidence. It is a strategy that has been actively pursued and promoted in 3 main ways. First, a non-binding international consensus on competition law has been created and fostered, largely under the auspices of the OECD, the UN Conference on Trade and Development, and the International Competition Network. Second, legal technical assistance is often provided to help draft competition laws and regulations, to provide training, conduct peer reviews, and to share best practices and experiences. And then finally, US antitrust law and EU competition law are referred to and promoted as model competition laws that are suitable to be, and in fact are, followed by and transplanted into other countries. Now, this narrative underlying competition law development and convergence is one that is largely dominated by Western and developed countries and their competition laws and perspectives, as well as international organizations and networks. So my paper explores whether this narrative still holds or does it need to be updated and or revised. To explore this question, I undertook a case study to look at the development of competition law in ASEAN and to evaluate whether and how their experiences fit into this dominant narrative. Now, why a case study on ASEAN? It's actually a region whose competition laws remain underexplored, even though there has been quite a lot of competition law activity in ASEAN in the past few years. Most of the research to date on convergence in competition law has been focused on the outcome. But convergence is not just about the outcome, it's also about the process. So the main aims of this case study are twofold. First, to examine the ASEAN countries' experiences in the process of drafting their competition laws, and then also to evaluate how these experiences may have shaped the enacted competition law. And the case study is focused on three main areas. First, the ASEAN member states with the most recently drafted and or adopted competition laws. The most recently adopted competition laws in ASEAN were enacted in 2015 by Brunei, Laos, Myanmar, and the Philippines. And one member state, Cambodia, is currently drafting its competition law, and it is the last member state in ASEAN without a competition law. So these 5 countries, which comprise 5 out of the 10 ASEAN member states, for all of them, competition law is a new and foreign concept, and they drafted and learned about competition law from a blank slate. Second, I limited the scope of the case study to the drafting of the competition law itself. The drafting of the competition law is the common experience across these case study countries, because not all of them have enacted a competition law, Cambodia being the outlier. Not all of them have established a competition authority, nor all of them have started to implement and enforce their law. So they're all at different stages, but the drafting itself is the common point. And then third, it is a case study that is informed by qualitative empirical research. I did in-depth interviews with people who were directly involved in the drafting of each country's competition law from the very early stages. So what are some of the observations and findings of the case study? On the whole, when looking at the text of the competition laws of these ASEAN case study countries, they seem to fit into the convergence narrative. But the case study countries all took quite different paths to drafting, developing, and enacting their competition laws. At the same time, there were some shared experiences and challenges across these countries. Now, the 4 key observations and findings of the case study are shown on this slide, but due to time constraints, I'm going to skip straight ahead to discuss the implications of these observations and findings for our prevailing understandings of competition law development and convergence. And of course, if you have any questions about the specifics of each country's experience with the drafting, or you have more questions about the 4 findings, I'm happy to answer them at the end of the presentation. So what does the case study tell us about convergence and the development of competition law? First, the case study questions some of the existing assumptions held by the wider competition law community about the direct relevance of US and EU competition laws to other countries, especially those whose economic, legal, cultural, political, and or governance contexts are quite different to that of the US and the EU. Relatedly, it also debunks the idea that US and EU competition laws have been directly transplanted into these ASEAN member states. Instead, 4 out of the 5 case study countries, that being Brunei, Cambodia, Laos, and Myanmar, all preferred to learn from other ASEAN countries when drafting their laws. In particular, they were most interested in learning about from those ASEAN countries that they considered to be most similar to themselves and to which they could relate to and identify with. Now, by contrast, interviewees commented that the country contexts in the EU and the US were just too different to their own. And this meant that the US and EU competition laws were of much less direct usefulness and relevance to them. And this learning from within ASEAN was reflected to varying degrees in the competition laws that were adopted by Brunei, Laos, and Myanmar, and noting that Cambodia's competition law is still a work in progress. Now, of course, the competition laws of the reference ASEAN countries were themselves shaped by the competition laws of other countries. So, to the extent that US and EU competition laws were influential in Brunei, Laos, and Myanmar, and might be in Cambodia, such influence, I argue, would have mostly been indirect and filtered through the competition laws and experience of other ASEAN member states first. So, I argue that these experiences suggest that intermediary countries can play an important role in developing competition law and in the convergence process. Now, what do I mean by an intermediary country? Well, it is one that a country considers to be similar, comparable, or relatable to itself. And that could be based on perceived similarities in legal, economic, cultural, linguistic, and or political traditions and systems, or on pre-existing relationships between the countries. Intermediary countries are more likely to be countries with developing, small, and or transitioning economies, and they represent a wider range of competition law experiences, as well as legal, economic, political, cultural, and linguistic contexts than the usual suspects of the US, EU, and other developed countries with mature competition laws. And I think that intermediary countries can play a valuable and to date really underexamined and underexplored and overlooked role in the development of competition law and be a mechanism of convergence. They help to bridge and narrow gaps and differences between the countries that are new to competition law and need to learn about it, and those countries from which that learning is usually obtained. Therefore, intermediate countries, I think, are important sources of learning, especially for developing countries who are new to competition law, and they help to facilitate convergence in an indirect way. Now, you might have noticed I have not yet talked about the Philippines. That was the only case study country that primarily referred to and directly engaged with US and EU competition law. And it seems that for the Philippines, unlike the other case study countries, they did not need an intermediary step to go from their local context to that of the US and the EU. And I think that this may be due to several factors. One, the drafters in the Philippines were comfortable with English and they could directly engage with English language materials, laws, and foreign experts. By contrast, the drafters in Cambodia, Laos, and Myanmar did face language barriers. Second, there's a historically close and strong multifaceted relationship between the Philippines and the US, which may explain their reference to US antitrust law. And finally, the legislators in the Philippines were assisted by local advisors with expertise on competition law, whereas the other case study countries did not have such assistance. The second implication is that most discussions of legal technical assistance in competition law tends to focus on evaluating its success and effectiveness and on how to design activities and programs. By contrast, this case study provides insights into how legal technical assistance can help to develop competition law in countries with limited prior experience with it and to facilitate convergence. Now, all the case study countries received legal technical assistance to support the drafting of and learning about competition law. The result of the assistance in the end is the same, a competition law that was broadly consistent with a number of other countries' competition laws and international norms. But the paths that they took to reach that outcome was quite different. The learning aspect of legal technical assistance seemed to play quite a significant role in the way that Laos, Myanmar, and the Philippines engaged with it. For these countries, the assistance was treated as an input and not a substitute for the drafting process. And this learning was reflected in the adopted competition laws. By contrast, for Brunei and Cambodia up until relatively recently, the focus of using the legal technical assistance seemed to more be on producing an actual draft of the law. Both countries largely entrusted the drafting of their laws to foreign experts. As a result, Brunei's competition law is essentially an exact copy of the Singapore's competition law, and the previous competition law drafts prepared by foreign experts for Cambodia were largely based on foreign laws and experiences that were familiar to the foreign experts, but not tailored for Cambodia. Now, the case study doesn't suggest that one approach is necessarily better than the other. In both Myanmar's competition law and the Filipino competition law, they contained, to varying degrees, some inconsistent provisions that are perhaps a result of not fully understanding particular competition law experts and concepts and their consequences, so suggesting a gap in the learning that was never plugged. And Cambodia's significant past reliance on foreign experts to prepare the initial competition law draft has not actually resulted in a drafted law yet. Cambodia is still drafting its competition law almost 20 years after it first began the process. The case study, I argue, also helps to highlight an overlooked aspect of legal technical assistance, which is its role in helping to bridge and narrow gaps and build relationships. Both the Philippines and Laos were aided by local advisors who acted as a bridge between the local drafters of the competition law and the local context on the one hand, and foreign laws, experts, and providers on the other. Legal technical assistance has also helped to develop and build ongoing long-term relationships between the case study countries and the providers of the legal technical assistance and the foreign experts. And it also helped to build and foster relationships between the ASEAN member states themselves. Finally, apart from Brunei, the case study countries did not enact competition laws that were substantially copies of another country's competition law. The competition laws of of Laos, Myanmar, and the Philippines are, to varying degrees, a mix of influences and learnings from within and outside of ASEAN, with modifications to suit the local context. So therefore, I think that the convergence of these recently adopted competition laws in ASEAN with prevailing competition law norms and with each other is more a reflection of the learning that the drafters took in these countries and what they absorbed, and of their efforts to craft a competition law that was suited to their country's circumstances, and less because they passively imported or transplanted a foreign competition law or international norms into their own legal systems. So, in conclusion, I believe that the case study into the recent experiences of developing competition law in ASEAN challenges, enriches, and expands the conventional wisdom of competition law development and convergence. On the surface, it seems that competition law convergence and development in ASEAN case study countries was achieved through the typical mechanisms, reference to US and EU competition laws and international norms, and also supported by legal technical assistance. However, when you scratch through that surface and examine the dynamics and processes of learning, drafting, and developing those laws that was undertaken in each of these countries, you get really valuable insights into and understandings of how these mechanisms actually worked to facilitate development and convergence. And that's my presentation. So thank you very much for your time. And if you have any questions, more than happy to answer them. Thank you.
Well, I think we can manage actually without the chat function. So guys, if you want to ask a question, just maybe raise your hand or we can just proceed. You ask a question directly by unmuting yourself. And I think we can do this in our group. So anyone has a question to Wendy? Because I have two at the minimum.
Oh, great.
So I would like to invite the participants first and then. Okay, so I'll go ahead.
Maybe, sorry, I'm also just thinking maybe competition law isn't super popular in comparative law.
Well, actually, I'll use my privileges then. I'll ask a few questions. It's one of the interests of mine, but I haven't been publishing in this area for a while. I'm wondering to what extent, Wendy, you would expect to see more convergence or less convergence when it comes to the enforcement of the laws that are being adopted in the region. So I understand you don't have data at this point to explore enforcement. You are more looking at the drafting and law in the book, so to speak. And for me, it's interesting to see that there is this intermediary step, so to speak, borrowing from countries in the regions with the similar, economic backgrounds, so to speak. So do you think there will be more convergence when it comes to the enforcement, or what your expectations are?
Enforcement is going to be really hard. And I think, you know, your point is right. The law on the books is different to actually law in practice. I think law in practice, even more so, will be exposed to the various economic, political, regional dynamics that are at play, and will probably change depending on the relationships within ASEAN or also external to ASEAN. I think where you have perhaps cross-regional conduct, where, for example, there was this merger between Uber and Grab, which is, Grab is kind of like an Uber for developed in Southeast Asia. And that was, I think, looked at in a couple of countries because they had the laws at the time. And in that type of situation, they did refer to one another's approaches and thinking on it a bit more. So enforcement's going to be a mixed bag. I think it would depend on the type of company. It would depend on the sector, especially also in areas of digital economy, where a lot more activity is happening outside of Asia, to be honest, especially in the EU. And there's a number of digital platform reports, etc., done by a number of countries throughout the world. I think those type of issues may be a bit more, they might look a bit more beyond ASEAN, whereas some more local conduct would be inside. But, you know, it's a really good point. I think I think the identity also of the intermediary country will change depending on the country, the conduct, the sector and time. They might find it easier and more useful to refer to some, and those identities may have changed from the ones that they referred to when they were drafting.
Yes, and I see two more hands, but may I quickly ask you, so when you compare it, you know, the ASEAN countries' experience with the experience of the United States antitrust and EC competition law, you said surprisingly, you know, you don't have direct borrowing, so to speak, right? There is a more similarities with the regional intermediaries. But if you go back to comparing with the US antitrust and EU competition laws, are there any particular areas where the differences are more drastic with the US and the EU?
But from ASEAN and US and EU, yes, or between US and EU? Oh, okay. So for example, Myanmar. Myanmar looked mainly towards Vietnam and Thailand. Mm-hmm. And one of the things it took up from Thailand, which was the 1999 statute at the time. Thailand has subsequently revised its competition law to when they were drafting. But Thailand took an approach that criminalized all conduct, which is not common at all. In the US, I mean, in the US, it's only criminal sanctions attached to serious cartel conduct, and that is it. And then Myanmar basically borrowed that from Thailand, and all conduct, anti-competitive conduct that fits in under the competition law in Myanmar is potentially criminal. So that's one thing.
Anti-competitive agreements such as franchising that have restrictions of competition can run you into trouble from the
potentially, yeah. Yes. Yeah, like vertical agreements, abuse of dominance, like those things can potentially be criminal. They're still, you know, drafting, implementing regulations that might change. They, you know, when I was talking to the people that are involved in drafting and enforcement, they recognize that there's a lot of inconsistencies and deficiencies in their law. But well, I mean, I don't talk about this in the presentation, but what was really interesting about Myanmar was they refused to take assistance to help them draft the law. They took assistance to help learn about the law during the drafting process, like learn about competition law, but they refused, you know, foreign experts' assistance to help them comment on it and things like that. So they do recognize that there are some gaps, and they're trying to address that in the implementing regulations. And they've been a lot more open in the drafting of the implementing regulations to foreign experts commenting on these regulations. So that's just one example.
No, and I can't ask you more, unfortunately. Thank you so much. So I think, May, you had a question first, and then we will ask Iran.
Yes, hello. Hi, everyone. Can you guys hear me? Yes, okay, great. Thanks very much, Wendy, for the presentation. So my question is about the motivation for conversion, and you've mentioned several of them in the presentation. And I'm wondering if you have seen any evidence or indication of the motivation not to be left behind by regional peers in your research, at least on the point of law on the book. And related to that, the motivation that if the law is unpopular, it would be easier to defend if other countries in the region also have similar law. And this really stemmed from my interest in general about indicators. So all countries, but especially small states like those in ASEAN, are subjective and perhaps influenced by these international indicators and ranking. And having at least good law on the book is one measure of that. So just curious about the motivation for conversion. Thanks very much.
So I said before that the 4 countries all adopted their laws in 2015. So 2015 was the deadline for the creation of the establishment of the ASEAN Economic Community. And so a lot of the motive at the push was for all the ASEAN countries to have adopted a competition law by 2015, which is why 4 of them adopted it then. The only country that didn't really feel the pressure and said, "Oh, go on my time," is Cambodia. So that's kind of the peer pressure. In ASEAN, these commitments, they're not really binding. All coordination and cooperation is by consensus, so they didn't necessarily have to do it, but there was that pressure to do it within ASEAN. From the point of view of like international kind of pressure to kind of feel like they're part of the international club. So, whilst the countries didn't really refer to US and EU competition laws, the countries did refer to international norms and standards. So they did refer to, in particular, the UNCTAD model laws on competition law. And what I found really interesting was that even though, and I've argued it elsewhere, that these international norms are reflective of a US, EU, and developed country perspective on competition law, and basically kind of take a lot of those approaches and make them international. The ASEAN countries, even though they still wanted to have their competition laws seen to be, following an international standard. Whereas they kind of just said, well, US and EU is just too far away from us, we can't look at that. But the content of the international norms is pretty much reflective of the US and EU as well. So I found that to be really interesting, and that there's still this pressure to follow international laws and regulations, especially because there is also a peer review process that Philippines was undergoing a peer review process at the same time as it was drafting its law, because they had this kind of little competition order that was never ever used before, and no one really uses it. So there is that kind of international pressure put on them, whether that be direct or just like inherent to them. They just want to be seen as part of the club. So sorry, that was a long answer.
Yeah, so let's pick one more question very briefly, if we may. And Yuran, please.
Yeah, so thank you, Wendy. It's really interesting. So I'm curious about foreign capital's role in like choosing a specific competition law. It comes to my mind that when you mentioned that the Cambodia just copied the Singaporean competition law. And
Brunei.
Brunei, but okay.
Brunei.
So but like I was doing like comparative garment industry like studies in many of these countries, and most enterprise or capital or factory owners in these countries are like factory owners from other Asian countries like Taiwan or Hong Kong or China. So I wonder whether they have some influence in which country, what kind of competition law they want to, like, if the country picks in learning and transplantation.
So first of all, in a number of these countries, especially the smaller ones, there was actually an active effort supported by development partners to go and, I guess, advocate for competition law, because there was resistance within the business community. Obviously, a competition law will disrupt the existing vested interests, etc., to really sell it. But so if anything, it was about lobbying, not about the form of the competition law, but kind of making sure that perhaps particular exemptions would be in the law, or that it wouldn't apply in particular industries, etc. But I'm not sure that was actually directly at the, because I mean, in all the countries except for the Philippines, the drafting process was really held by the ministry, which happens also to be like to house the secretariat of the competition agency nowadays. So it was the ministry that was usually the commerce or industry ministry that would shepherd the law through the drafting process up to the legislature. And even then, the legislature doesn't really change the content of the law. So there might have been some influence or lobbying, at least, in that to the drafters, but also really to the various ministries more attached to those industries and businesses to exert influence as that law went through the government departments, in consultation, etc. So I don't think that was kind of like businesses weren't so much worried about the exact, reference country to learn from. It's because most of the time competition law is so converged that people kind of know what to expect, what will be covered. So it's more a matter of like, get me some sort of exemption. And if it's going to apply to me, then I need to know exactly what's going on, type of thing.
Thank you so much, Wendy. And before you leave, could you please?
No, I'm going to stay. I'm going to stay on as much as I can.
Could you please assign me as a host, and or maybe
Sure.
we can. Can you assign Alperen next? He will be our next presenter. So just click on his picture, and then you should be able.
Host.
Yes. So
change host. He is the host now.
He is the host. Okay. If you wanna. Thank you so much.
Thank you so much for everybody. Thank you.
Hi everyone. I would like to share my slides as well. Do you see my slides now? Okay. Hi everyone again. Thank you for the opportunity.
Before you, Alperen, I can't really hear you loudly enough. I don't know if you can move closer or just check your mic.
Okay.
Maybe we do, but speak louder.
Okay. Okay. Again, thank you for the opportunity to present in this great conference. My research is entitled Blinded by Fairness, Why We Need Strong Procedural Safeguard in Screening Self-Dealing. Let me start by giving a little bit information about my topic. My topic is related party transactions. So what is a related party transaction? It's a transaction entered into by directors, managers, or controlling shareholders of a company, which I will be calling corporate insiders, with the company itself. So let's assume that there's a shareholder with shareholding about 50% of shares of the company. And if this shareholder enters into a transaction with the company, that transaction will be called related party transaction. And such transactions can actually be used by these parties, these corporate insiders, to expropriate company value to enrich themselves at the expense of other stakeholders of the company. So let's also assume that this controlling shareholder wants to sell a land to the company, and since he or she controls the company on the other side of the transaction, he or she can extract favorable terms than the company would have actually agreed to in the market when transacting with the third parties. So this controlling shareholder can actually divert company value to themselves and actually harming the company value. For this reason, such transactions are regulated around the world to protect company value and investors in capital markets. No jurisdiction actually directly ban related party transactions except a few examples, because such transactions can also be beneficial. They are not always harmful. So what jurisdictions try to do is to try to understand which transactions are beneficial, which transactions are actually harmful. And there are two main ways of doing it. There can be some procedural safeguards, which are ex ante, which means they apply before the transaction has been entered into by the company. And there are two main types of procedural safeguards. There can be the requirement that disinterested shareholders approve RPTs, so this controlling shareholder enters into a transaction with the company, and other shareholders get the opportunity to vote on the transaction, and they can veto the transaction or approve the transaction. Or secondly, there can be the requirement that independent directors of the company approve such transactions. Instead of these procedural safeguards or alongside these procedural safeguards, there can be also court review of such transactions, which is ex post, which means it happens after the transaction has actually been entered into by the company. And what courts generally do is to look at the terms of the transaction and to compare the transaction to a market transaction to understand whether the company has actually been harmed by the transaction, to understand actually whether the transaction has been fair. So this court review has actually been also called as fairness review. So let's actually look at which tools do jurisdictions actually use. And firstly, to Delaware law. As you may know, corporate law is a state law, a matter of state law in the US. Federal law is of limited significance, and Delaware law is the most relevant corporation law because most corporations in the US are incorporated in Delaware. In Delaware, general corporation law does not mandate any use of procedural safeguards, so RPTs are subject to review by the courts, and courts apply the entire fairness test. And this test has actually two aspects. First, fair dealing, and secondly, fair price. In fair dealing aspect, courts have required companies to follow up steps that mimic an arm's length bargaining, and through this requirement, they actually introduce procedural safeguards through the back door because they require companies, for example, to have independent board committee review the transaction to obtain independent financial advice and to have the power to veto the transaction or approve the transaction. And secondly, they also looked at fair price, which is intuitive. They looked at the financial and economic consideration of the transaction. They also incentivize the use of procedural safeguards through changing standard of review or burden of proof when they review the transaction, but I will not go further into detail because of time constraints. Let's look also at some European jurisdictions. In Germany, we see very limited use of procedural safeguards, and the law is heavily dependent on the review, court review, based on several civil law and criminal law provisions. In France, we see a better use of procedural safeguards, but it is still mediocre, and the law is substantially dependent on the court review. In Italy, there is the requirement that independent board members approve the RPTs. And in the UK, there is a requirement that disinterested shareholders approve RPTs. So in these two jurisdictions, we see strong use of procedural safeguards. But in the EU, there has been a new directive, Shareholders' Rights Directive 2. It requires member states to implement a sort of procedural safeguards in their regulatory toolbox. As you can see, there are three main options. They can choose approval by disinterested administrative or supervisory body, or approval by disinterested shareholders, or a combination of both. In this research, I inquire about how we can move towards a more effective regulation of related party transactions based on insights from behavioral economics. So corporate law generally and self-dealing law or RPT regulation specifically has been very much dependent on traditional economic analysis, which was based on rational actor model, so Homo economicus. And this analysis tells us that corporate insiders will expropriate company value because it is in their self-interest, so they will show the competitive behavior. So what jurisdictions should do, they should put in place some legal and market mechanisms to prevent this value diversion. But this analysis does not tell us any difference between procedural safeguards and court review. What jurisdictions will do to devise their RPT regulation in accordance with their idiosyncrasies. So for example, courts in a jurisdiction, if courts are not effective, that jurisdiction will tend to choose procedural safeguards. But when we look at the insights from behavioral economics, which has gained a lot of traction as a field recently and has made a lot of inroads to corporate law, insights from behavioral economics suggest that corporate insiders may not expropriate company value, even though it is in their self-interest. So please note the contrast here. In traditional economic analysis, corporate insiders will divert company value because it is in their self-interest if there are no legal mechanisms to prevent this. But behavioral economics tells us that they may not expropriate company value even though it is in their self-interest. What matters in this context is to create a social context that promotes this cooperative behavior. So cooperative behavior in this context is not diverting company value. And in my view, this indicates that utilizing strong procedural safeguards may lead to a more robust RPT regime. More specifically, experiments by psychologists and behavioral economists indicate that people can behave in a way that is socially optimal, but is not necessarily in their best self-interest. For this, social context should be inclusive to promoting cooperative behavior. And my main argument here is utilizing procedural safeguards comes with the added advantage of framing a setting for cooperative behavior, while a sole exposed court review of merits of RPTs would damage such a setting. Let me elaborate a little bit more on this argument, and let's think about two different situations. First, when there are some procedural safeguards in place, and this frames the RPT setting as a process where other stakeholders are involved through approval requirements and discuss over the merits of the transaction. So if there's a requirement that disinterested shareholders vote on the RPT, controlling shareholder cannot freely enter into RPT, cannot dictate the terms of the RPT with the company. He or she needs to discuss the transaction with other shareholders, discuss over the merits of the transaction, and need to negotiate over the transaction. So this context signals a call for cooperation for corporate insiders, which may indeed trigger this. So it creates a cooperative setting, which we know is more conducive to cooperative behavior. But when there are procedural safeguards, corporate insiders are at large to deal with the company without any input from disinterested or independent bodies. This is similar to imposing an involuntary transaction because there's no approval requirement. They can dictate the terms of the transaction with the company. They can dictate whether the company actually enters into transaction. So they can freely enter into RPT, which courts may scrutinize. Because other interested parties need to become aware of this transaction through disclosure requirements, and they need to decide whether to bring this RPT before the court for the review. And courts will at most require compensation in the end. So in this context, other stakeholders must play tag to make corporate insiders account for their behavior. Such a context, in my view, both assumes and legitimizes the adoption of a purely self-interested preference function, which creates a competitive setting, which we know is more conducive to competitive behavior. Furthermore, behavioral economics tells us that people have a tendency to discount hyperbolically. In other words, they reward more imminent benefits while discounting more the non-imminent punishment, which is irrational. So what happens in the case of exposed court review of RPTs, corporate insiders are to account for the harm suffered by the company after they enjoy the benefits for a while. So they enter into a transaction with the company they control. They divert some company value. They enjoy these benefits, and if some shareholder decide to bring a suit before the court and court decide on some compensation, corporate insiders pay some compensation. So there's time difference between the enjoyment of benefits and compensation of the harm suffered by the company. So in such a case, corporate insiders will not be very much concerned irrationally with the consequences of their breaching due to a hyperbolic discount while they enjoy immediate benefits. This is also not conducive to promoting cooperative behavior. Lastly, experiments of behavior show that the decision to cooperate or not also depends on the participants' perceptions of others' expectations and likely behaviors. So if you're in a social context where people behave in a way that is optimal for the people in that community or society, not in a way that is necessarily in their best selfish interest, you also start to act in that way. So applying this insight, Blair and Stout argued that fiduciary lawsuits against corporate insiders unavoidably send the signal that others in the business world are choosing to violate their fiduciary duties. The more suits brought, the stronger the signal. So if you're in a social context where there are a lot of fiduciary lawsuits against corporate insiders, as a corporate insider, you tend to think that violating your fiduciary duty is normal and common in that context. So you also start to act in that way. Similarly, in our context, the higher the number of cases that concern value diversion from the company by corporate insiders, and thus the breach of fiduciary duty, the more likely that such a behavior will be signaled as normal and common to corporate insiders. This is similar to concepts of social influence or reputational externalities, So what is the advantage of applying a strong procedural safeguard is that value diversion will be prevented within the company. So if there is the requirement that some RPTs have to be approved by independent board committee, and hopefully they will veto some value diverting transactions, those transactions will not come before the courts, and there will be less fiduciary lawsuits before the courts. There will be less signal that such a behavior is normal actually in that context. So what to conclude from this analysis? I argue that the existence of procedural safeguards may harness the social context necessary to impede the self-regarding function of corporate insiders, but not every procedural safeguard will function in this regard to the same extent. Potential effect of the procedural safeguard will be a function of its ability to create a real arm's length bargaining environment. On the other hand, one may argue that the value of constructing a setting which promotes cooperative behavior may be doubtful in the face of extensive legal and market mechanisms in the today's capital markets. Yet, I would reply that each mechanism in the today's capital markets has its own costs and limitations, and lawmakers should consider in the cost-benefit analysis of such measures how they affect the internal preferences of corporate insiders based on behavioral insights. In the beginning of my presentation, I gave a brief overview of legal regimes, how they regulate RPTs, and now I would like to evaluate such regimes against insights from behavioral economics, as I try to argue that behavioral economics, insights from behavioral economics are in favor of utilizing strong procedural safeguards because they create a social context that is conducive to cooperative behavior. And in Delaware, Italy, and the UK, we see strong procedural safeguards, so they are in line with the insights from the behavioral economics. But Germany and France are not, because they have weak procedural safeguards. But the new shareholder rights directive is a welcome development as it requires member states to adopt at least a procedural safeguard. But the end effect will depend how strong a procedural safeguard that member state adopts, because as I said, member states have a great deal of discretion in designing a procedural safeguard. So in conclusion, this study indicates the benefits of the ex-ante strong procedural safeguards in contrast to a mere ex-post review of substantive merits of RPTs by courts, in consideration of creating a social context that promotes cooperative behavior by corporate insiders based on insights from behavioral economics. I put here two further research questions that are, in my view, worth pursuing. Firstly, there is evidence that jurisdictions that employ strong procedural safeguards are better at curbing value diversion by corporate insiders. But to what extent is such a result attributable to social context that is intuitive to cooperative behavior? So, to social context that strong procedural safeguards create, or to strong external controls which such mechanisms actually provide. And secondly, how likely is it for the behavioral insights observed in the social experiments to be duplicated in the context of self-dealing RPTs? As I said, we always assume that corporate actors are rational agents, so it is dubious how behavioral insights we observe in social experiments can be valid in the corporate setting. And I suggested here field testing as a way to understand this phenomenon in corporations. That's all from my side. Thank you very much for listening, and I look forward to your questions, if any.
Thank you, Alperen. Let's leave, guys, all questions until the end then. And could you, Alperen, pass on the baton to Chiao Wan? You should be able to click on his picture and then in the top corner, find the menu, and then you just say, make him a host. Did it work?
Yeah.
Wonderful, thank you. Don't forget to mute yourself, and I'll mute myself also. So Charles, you're in charge. Charles, I don't think we can hear you. I don't know, at least I cannot. Something had happened once you moved into the presentation mode. Oh, now we can hear you. Can you say something? No, we cannot. I thought we can. Maybe it's the settings of your. You know, if the presenter mode does not work, you can just go back to PowerPoint and I believe move through slides without using the presenter mode. This should address the problem. Alperen, you're the host again. It says for some reason. Okay, now Chao is the host now. Charles, I think can you exit from this presenter mode for the PowerPoint presentations and go back one step? And so now open your slides and you can just make it large, you know, like zoom it and move through slides without making the, no, we cannot hear you. If you want, we can give a word to our next presenter. And then meanwhile, maybe you can adjust. We could hear you before you moved into PowerPoint, right, guys? You want to check the settings for your sound, for your mic. Maybe something happens. Maybe you have external monitor. I have this. And so the sound goes to the external monitor. Can you speak now? We don't hear you. So no, we can see that you try to talk, but we cannot hear you. At least I cannot. And it seems like nobody can. Okay, so Alex says no. Let's go to our next presenter. And Charles, I don't know if you want to restart your computer or something meanwhile and come back to us. Hopefully it will address the issue. Sometimes it helps. And I'll come back to you next then. So Karasahin, Alperen, please. Oh, actually, Charles. Host. Who is the host now? Antonia is the host.
Yeah,
all right.
I am. Okay.
So can you make the Alperen the host, please?
Sure.
Thank you. Well, it's nice to have a safety net. Okay, so
all right.
Yes, perfect.
I see that I'm the host now. Can everybody hear me?
Yes,
properly?
we can.
Okay, thank you. Let me share my screen first. Now, I will begin, just a minute. I will begin my presentation by providing a description for the term comprehensive security right. In this presentation, the term comprehensive security right will be used to describe non-possessory security rights that are created by a single agreement and encumber all assets or a class of assets of the security provider. This statement should not be understood as an exact definition of a concept, but rather as a description of typical features of the security rights that I deal with now. A typical example of a comprehensive security right can be found in UNCITRAL Legislative Guide on Secure Transactions. It's the All Assets Security Right, and its name is self-explanatory. So I will only highlight some characteristic features of this comprehensive security right. Firstly, several assets of the security provider are encumbered by a single security agreement. Secondly, the assets that are encumbered are future assets as well as present assets. And finally, typically, comprehensive security rights give the security provider the authority to dispose of encumbered assets in the ordinary course of business. Now, after this brief description of comprehensive security rights, I would like to move on to the risks caused by comprehensive security rights. Now, security has a lot of advantages for finance, but it can also cause some risks for related parties. Firstly, especially comprehensive security rights can cause risks for the security provider. The security provider might not be able to use the full value of its assets for obtaining future credit from other creditors. Indeed, other potential creditors might not be willing to accept security in the second rank or a lower rank on previously encumbered assets. So the first secured creditor might have a credit monopoly on the security provider, which would or which could limit the economic decision-making freedom of the security provider to an important extent. Comprehensive security rights could also cause risks for third parties, especially unsecured creditors of the security provider. Unsecured creditors might not be able to collect their claims in case of insolvency of the security provider, since the assets of the security provider have already been completely or to a great extent encumbered in favor of a secured creditor. Now, the problem that should be analyzed can be formulated as follows. How do different legal systems, if at all, provide for protection of the interests of the security provider and third parties against risks caused by comprehensive security rights? In this presentation, I will provide a brief overview to English law and German law. In English law, the company charges can constitute comprehensive security rights as described before. The charge is defined as a non-possessory security, whereby the charged property is appropriated to the discharge of an obligation without the transfer of ownership. Now, company charges might be have two types. They might be floating charges or they might be fixed charges. There is one single criterion for the distinction between these two types of charges. The criterion is the ability of the security provider to dispose of encumbered assets in the ordinary course of business without prior consent of the secured creditor. If the security provider has this ability, the charge is a floating charge. Otherwise, it is characterized as a fixed charge. Since this is the difference that determines the distinction, in other respects, the differences between floating and fixed charges might not be present. For example, both floating and fixed charges can cover several present and future assets. So both of them could actually constitute comprehensive security rights. The typical comprehensive security right in English law has traditionally been the floating charge. Indeed, the floating charge includes all three characteristic features of comprehensive security rights. The assets covered by it can change until the secured creditor enforces its right and thereby crystallizes the floating charge. The assets that have been disposed of by the security provider leave the ambit of the charge, and the assets that take its place are automatically within the ambit of the floating charge. English law contains some protection mechanisms against the risks caused by floating charges. These mechanisms can be found in the priority rules related to floating charges. Firstly, preferential creditors have priority over creditors secured by floating charges in insolvency. This is a highly unusual rule for proprietary securities. Secondly, part of the value of assets encumbered by a floating charge is reserved for the satisfaction of unsecured creditors. This is described as a carve-out. Finally, a fixed charge over the same assets has priority over a floating charge, even if the fixed charge is created later than the floating charge. Thus, the security provider who has already created a floating charge over its assets can create a fixed charge or use a fixed charge on the same assets to obtain further credit. Now, these protection mechanisms has made the floating charge very unattractive to creditors in practice. Indeed, it is possible and quite common in practice to use fixed charges to evade these protection mechanisms. Floating charges are now only used to cover assets that cannot be practically covered by the fixed charge, especially circulating assets, because these assets need to be or have to be disposed of in the ordinary course of business. All other assets are encumbered by the use of a fixed charge, and thereby the protection mechanisms provided for floating charges are evaded. Now, in the English legal literature, the priority rules about floating charges are criticized in several respects. I will only emphasize one criticism here in this presentation. The use of the concept of floating charge as the trigger for protection mechanisms is found to be inappropriate to reach the aim of these protection mechanisms. If the law should provide some protection to the security provider or third parties, the mechanisms for such a protection should be applicable to fixed charges as well as floating charges. Although there are some opinions to the contrary, a lot of authors actually criticize the possibility of evasion of these protection mechanisms, not the presence of these mechanisms themselves. After this brief overview of English law, I would like to move on to German law. Now, German law does not have a specific type of comprehensive security right, like an enterprise charge or a floating charge. However, the security transfer of ownership and security transfer of receivables can be used to create comprehensive security. In German law, the transfer of ownership of movables is possible by constructive delivery, so that the transferor can remain in control of the movables. Furthermore, the transfer of receivables is effective without any requirement of registration or notification to the account debtor. In German law, several movables and receivables can be transferred for security purposes with one agreement, as it is usual for comprehensive security rights. Finally, in German law, it is accepted to transfer the ownership of movables or transfer receivables in advance, that is, anticipatorily. In other words, future assets can be transferred for security purposes with the use of these devices. In German practice, it is usually provided for in security agreements that the collateral may be processed, or sold by the security provider, and the security right automatically extends to the products or proceeds. As can be seen from these explanations, in German law, the security transfer of ownership and receivables can be used to create a comprehensive security with the typical features of these security rights. German law provides for protection against over-collateralization. Now, this protection is granted by or developed in the case law of the German Federal Supreme Court. The court held that the secured creditor has an implied obligation to release some collateral if the security becomes disproportionate to the secured claim. The court does not stop here. It determines an exact ratio for the presumption that the security is disproportionate to the secured claim. The parties may prove that the security is not disproportionate despite the presence of such a ratio in the present case. However, the presumption and the use of an exact ratio make the application of this case law very practicable. There are also some mechanisms developed by German legal doctrine. It is argued and accepted generally that the general prohibition of immoral contracts can be applied if the security is disproportionate at the time the security agreement was concluded. The German Federal Supreme Court did not yet have to decide a case on this specific point. However, it has expressed the possibility of the use of the general prohibition of immoral contracts and thereby supported the doctrine in an obiter dictum. Now, after this overview of English and German laws, I'd like to move on to the legislative guide on secure transactions prepared by UNCITRAL. The legislative guide recommends states to allow all asset security rights without any limitations. The guide states that such limitations, which are intended to provide some protection for grantors and unsecured creditors, usually end up limiting the credit available to debtors and increasing its cost. Now, this supposition needs to be scrutinized critically. The rules and the practice in English law and German law has shown that there is a need, social need for some protection mechanisms against comprehensive security rights. And the serious counterproductive effects that are feared by the legislative guide have not been extensively reported in English and German literature. There are, of course, some criticisms to the mechanisms developed in both legal systems. However, a serious counterproductive result has not been reported, to the best of my knowledge. As a final remark, I'd like to state the following. It is quite unlikely that the recommendation in the legislative guide will be found acceptable in all states. So there are states that will need and that will legislate for some protection mechanisms. For them, a comparative law analysis based on English and German laws can provide valuable insights for an effective mechanism to protect the security provider and third parties. I will be very happy to answer any of your questions at the end of the presentations, and I appreciate any comments in this regard. Thank you for your patience.
This was great. Thank you, Alperen. So shall we give it another try to Charles? And if so,
can you hear me now?
Yes, we can hear,
yes.
But Alperen, you need to transfer the host functions to Charles. And to do so, click on his picture, please. And there should be the 3 dots. Okay.
Okay, thank you.
Thank you.
Thank you so much. Yeah, everybody can hear me now. I'm sorry for the interruption. I will make it quick. My name is Charles Wang. I'm currently a research assistant and a recent PhD graduate from the Chinese University of Hong Kong Faculty of Law. My topic today is about the law and practice of substantial shareholding disclosure in China. From comparative perspectives and recent development. First, let me introduce the disclosure regime. This substantial shareholding disclosure regime originated from the United States Securities Exchange Act of 1934. In Section 13D, it states that any person after acquiring over 5% of the shares of a listed company, it shall within 10 days file a statement with the SEC, the Securities Exchange Commission. And after that, the investor become a blockholder, and every increase or decrease of over 1% shareholding should also be disclosed in the same way. In the 1990s, China established its stock market to borrow rules from the United States of America and the United Kingdom via Hong Kong. That is another example of intermediary countries. Hong Kong is the intermediary jurisdiction for China to borrow rules from the West because China needs to list its companies, especially state-owned enterprises, in the Hong Kong Stock Exchange. So, and the first national securities law of China and revised in 2006. Recently, in 2020, the securities law was overhauled and takes effect in March. As a shareholding disclosure regime was revised. So my protect the primary comparators are the United States and the United Kingdom, because Chinese securities law were mainly imported from these two jurisdictions. And I will also do case studies focusing on the CSRC, the China Securities Regulatory Commission's regulatory cases in the Chinese stock market. My basic conclusion is that the recent reform in 2020 on China's national securities law was in a wrong direction, because it converges. It is expected to converge with its United States model, but this convergence should be reconsidered because it is not suitable for China's local context. My article is from Divergence, just as Wendy's topic. So there are benefits for this disclosure rule, because shareholding disclosure primarily enhancing market transparency in the stock market. It protects ordinary investors and improve corporate governance, because generally speaking, ordinary investors, they do not owe any duty to the listed company. The listed companies have the information disclosure duty to the investors. But when an investor shareholding reaches a certain level, for example, 5% in the United States, or also in China, then the investor become a blockholder. It has a duty to disclose its shareholding to the society, to the listed company, and to other investors, for them to make better and inform the investment decisions. But there are also costs associated with this regime, because firstly, it increases tremendously the transaction costs, as well sometimes the takeover cost for the investors, block holders. Sometimes they are hostile acquirers in a hostile takeover scenario. So the block holders, they are outsiders. They can monitor the performance of the directors of incumbent directors of the company. So they can pose a potential threat to the directors and managers in hostile takeovers. So they can monitor the corporate governance. So by weakening the position of the block holders, the shareholding disclosure regime can harm corporate governance. On the other hand, it can be easily circumvented by means of acting in concert with other people. So there was a debate in the United States, which took place in 2013. Some practitioners filed a petition to request the SEC to shorten the 10-day disclosure window to 1 day, because they think that the 10-day window is not enough to protect the investors who are entitled to full disclosure. And there have been some loopholes since the regime was invented in 1934. But Professors Babchak and Jackson, they argue that the block holders can contribute to market efficiency by accumulating shares in the public company and monitor the corporate governance of level of the target company. So in history, the drafters, the lawmakers, they did not intend to deter the block holders, and there should be a balance between the directors and the block holders. So the law should not weaken the block holders too much to entrench the directors of that company or listed companies. So in China, the old securities law, which took effect in 2006, generally copies the regime from the United States, but there are some divergences. For example, the 10-day disclosure window was shortened to 3 days. And the disclosure threshold is the same, identical to the United States, which is 5%. But the 1% disclosure interval was stretched to 5%, increase or decrease. So what is the biggest divergence from the United States original regime is that there is a so-called walking slowly rule. So within the disclosure period, the investor or the block holder, they may not purchase or sell any more shares of the listed company. Otherwise, they will be punished. So this is the biggest divergence from the American style regime. Accordingly, there are two kinds of legal consequences. The first one is Article 193, which is to punish the violators of the disclosure, the non-disclosure, the violators of the disclosure requirement. So there's correction, warning, and an administrative fine, which can be up to 600,000 yuan. But it has been criticized by many people as not enough for to punish the people, because although 600,000 yuan is a big number to me, it is equivalent to for 4 years scholarship for a PhD student, but it is not enough to punish those violators of the disclosure requirement. But there is another punishment for the walking slowly rule. Article 204 of the securities law, which can impose fines of no more than the equivalent value of the securities as traded. This is a big number, and in practice, it is often 10 times, more than 10 times higher than the 600,000 yuan. So by invoking Article 204, the punishment can be made much more severe. So in practice, according to my empirical research, the CSRC has been selectively invoking these two articles. In all the cases, the Article 193 has been invoked, but only in some of the cases, Article 204 was invoked. And in 2020, the securities law was reformed, and and in terms of behavior mode, the disclosure interval was changed from 5% to 1%, which converges with the United States model. So it was strengthened to be more strict than before. But in terms of legal consequence, the Article 197, which is inherited the Article 193, raised the administrative fine for violating the disclosure rule to 5 million yuan. It takes into consideration the high inflation rate in the last decade in mainland China. So Article 186 is identical to Article 204, which is to punish the violators of walking slowly rule. So there's no difference. But there is a third punishment, which is to disenfranchise the violators. So the violators of the regime cannot exercise voting rights for 3 years, which is to deter the potential acquirers in the scenario of hostile takeovers. So I did a cross-jurisdictional comparison between China, the United States, and the United Kingdom. So generally speaking, China converges with its Western counterparts, but in the most important divergence is the walking slowly rule. And there is no systematic exemption mechanisms exist in China. So it is China's regimes, disclosure regimes is much more severe, much more stringent than the United States and the United Kingdom. So it contradicts Professor Skelton and Professor Siam's thesis that developing countries tend to have less stringent disclosure regimes than developed countries. And the stringency of the regime is positively correlated to the degree of ownership dispersion in a jurisdiction, because China is a developing country that has concentrated the most concentrated shareholding structure in the world. So it is an outlier from the general theory. So why I explained in my article from the perspectives of national interests and the political economy and other local factors in China. So we can see that in the United Kingdom, it is a dual structure regime. For domestic listed companies, the threshold is lower, and the disclosure interval is lower, 3% and 1%, and the disclosure window is shorter, 2 days, than the foreign listed companies. Foreign companies that are listed in the London Stock Exchange, they are treated comparatively. They are treated less stringent. So that means that also it testifies that it indicates that developing countries they need to take into consideration their own development stage, and the block holders in the listed companies of developing countries tend to at a disadvantage compared with their counterparts in developing countries. So my empirical research they examine the cases decided by the CSRC, the market watchdog in mainland China. And from 2008 to 2017, there are in total 85 cases. So most important finding that in 2015, there are 33 cases, most cases in all the years, because generally speaking, this regime has not been functioning very well in China. There was less than 10 cases in most of the years, but in this year, 2015, there has been more than 30 cases. But why? My research found that this is because the stock market crash in China, which took place in 2015. The CSRC has a task, political task of dealing with the violators of the disclosure regime. The violators massively and secretly decreased their shareholding in the stock market. So which caused the stock market crash. So to stabilize the market, the CSRC has decided the most cases in that year. Generally speaking, most cases has been dealt with within 2 years of violation. So the CSRC has been efficient in legal enforcement. And most cases happened in the stock exchange trading in Shanghai and Shenzhen, which is the focus of the CSRC regulatory public enforcement of the securities law. We can see that in terms of the behavior patterns in the stock exchange trading, the most cases have taken place in the scenarios of the investors shareholding reaching 5% to become a block holder, and the block holders decreasing, shareholding decreasing by over 5%. So the block holders increasing by 5% has not been the focus. Because also the CSRC's the regulators' agenda has been focused on to stabilize the market. So the decreasing by over 5% is more harmful to the market. So in all the cases, the Article 193 has been invoked. But my focus is on whether the Article 204, which is the punishment for the walking slowly rule, has been invoked. So in half of the cases, it has been invoked. Also, we found a similar interesting phenomenon in 2015. Among all the cases, nearly only one case that has not been invoked by invoked Article 204. That means in that year the CSRC has used all the weapons, including the walking slowly rule, to punish the violators who caused the stock market crash. Sorry. And often, also this lead to the administrative fine of that year has been 10 times higher than the normal years. That is the result of the walking slowly rules enforcement, which is the biggest divergence of the China's shareholder disclosure regime. And in that year, there is an unofficial public apology punishment tool invented to deter the violators it is not written in the securities law, and it was invented and only enforced in that year. So that is a kind of reputational sanctions in China's stock market, which has not found its way into the national securities law. So my conclusion is that there are two principles that need to be considered in evaluating the reform. The regime should consider the balance between incumbent directors and external investors. And it also should consider the economic development stage of China, of a jurisdiction. So the reform in 2020 of China's securities law has not been conducted in a right direction because China's blockholders, investors, has been at a disadvantage due to the concentrated shareholding structure. They cannot challenge the powers of the incumbent directors and the controlling shareholders. They are very weak. So by weakening them further, the reform can undermine corporate governance in China, especially is harmful for the shareholder activism in China, the emerging shareholder activism in China. And it increases a blockholders' burden in favor of the incumbent directors. And often we can learn from the United Kingdom's experience that the economic development stage must be considered. China is a developing country, so it is not good for China to adopt a regime that is as stringent and even sometimes more stringent than the developed countries. So it may discourage the market participants from disclosing their shareholding. And the walk and slowly rule should be abolished. Before that, it should be flexibly and fairly applied to all the cases, because it is unreasonable for the regulator to decide whether to invoke the walk and slowly rule to its own needs. It is not rule of law in the stock market, and there's no clear and consistent criteria for invoking whether or not to invoke the rule. So in terms of disenfranchisement, my article supports it because the legal consequences, the public enforcement should be strengthened. It does not contradict a tolerant disclosure regime. So it is reasonable for the reform to add the disenfranchisement clauses. So that's my presentation. Thank you so much.
Yes, thank you, Charles, and for being so efficient. Can you please then pass over the host functions to Tran?
Oh, sorry. Thank you. How to?
You just click on her image.
Okay, yeah, thank you.
No, but you just please click on Tran image on her picture. And then
actually, I don't have slides, so I
don't have slides. Okay, but then can you do this so I can become a host? Anyways, please, Tran, go ahead.
All right. So thank you very much. Hello, everyone from Philadelphia. My name is Trang Minh Nguyen. I'm an assistant professor of law at Temple University, Beasley School of Law. It's a pleasure to be here today. Thank you to Professor Corzun for chairing this panel, Professor Baraja for organizing. Thank you, Wendy, for staying, even though I know it's so late in Australia. So I'm presenting today a very early work that is still taking shape. There's a lot of gaps to be filled, and I'll strive to be brief, and I'd love any thoughts or suggestions. So the paper is tentatively titled Relational Supply Chains: What Happened When Cattle Ranchers Go Abroad. The paper used COVID-19 as a lens to study how business partners deal with changed circumstances in international contexts. And the cattle ranchers in the title, of course, refer to the ranchers in Shasta County in California, made famous in American law through Robert Ellickson's classic book, Order Without Law: How Neighbors Settle Dispute. The book finds that in close-knit communities like ranching in rural California, social norms and custom trump legal rules. Because they know each other so well, the ranchers can settle disputes more efficiently among themselves. And even more importantly, the norms they have developed are substantially more beneficial or welfare maximizing, in Ellickson's words, compared to legal rules. So Ellickson's work dovetails with a rich literature in contract law, so aptly named Relational Contracts, developed by the Wisconsin School of Contract Law, Ian McNeil, Stewart Macaulay, who emphasized the use of informal contractual arrangements to preserve the trust and flexibility so crucial for long-term relationships. Relational contracts, scholars have found, are robust in close-knit communities and industries, populated by repeated players, from the cotton industry to Jewish diamond merchants in New York. And this is, of course, the work of Lisa Bernstein from Chicago. And while those communities elect not to utilize law, the shadow of the law is long and pronounced, playing a background role that informs and sets the stage for informal norms to develop. Later development of relational theory has found that norms don't simply displace law, rather they are complementary, intertwined, braided. This is the braiding theory of contract. Formal contract acts as framework for parties to share information and generate trust, enabling parties to then arrange their interaction with flexible commitments. So unsurprisingly, law is highly relevant, even if it has to share the center stage with norms and customs. Well, in today's globalized war, very few communities can remain so close-knit and insulated. Even the Cattle Rancher Association of California had endorsed the TPP, the Trans-Pacific partnership back when it was alive. So what happens when cattle ranchers are faced with disputes abroad, specifically those that arise in supply chain contexts? And as we've seen, those disputes are rendered so widespread by COVID-19. And given that conventional wisdom so often highlights the heavy relational aspect of commercial relationship in Asia, that is the home to the majority of supply chain host states, how do parties deal with supply chain disruption? Will we see relational contracts on steroid, all relational? Or will contracts be irrelevant altogether? Just the bigger company dominates renegotiations. And all the talk we have heard about the force majeure clause, are they relevant on the ground at all? So my paper seeks to investigate these questions. It seeks to extend relational contract theory to the international spheres, both descriptively and normatively. So descriptively, I'm seeking to better understand how suppliers and their business partners renegotiate and navigate the changing war caused by COVID-19. I'm conducting interviews or virtually, of course, through Zoom and Skype and whatever other platform, with lawyers, business managers, trade association representatives, and policymakers in 2 host countries in particular. So far, most of my interlocutors are from Vietnam, where I have a lot of social ties, and I have also just started chatting with Chinese colleagues and interviewees. I'm focusing mostly on the textile and apparel industry, which has gone through a drastic transformation from producing clothes to now trying to pivot to mask and PPE, personal protective equipments. And as such, lively renegotiations have been happening and are occurring, both in breaking old commitments and establishing new ones. Now, on the normative side, bringing relational contracts abroad means having to unravel some of the core features that enable a relational contract to function in the first place. And I will just highlight 2 here in the interest of time. First, most obvious, the groups are no longer close-knit, though they are not exactly strangers. When a corporation like, let's say, Walmart or Nike buy from a host country, like China or Vietnam, Bangladesh, they typically deal with a repeated group of major suppliers who sometimes are multinational corporations in of themselves or are highly vertically integrated, or could act as a middlewoman to coordinate production from lower tiers sub-suppliers. So while the supply chain may run deep and involve millions, 10 millions of workers, the group of actors at the top are finite with repeated interactions. So that can facilitate some informational exchange and raise the reputational costs. Those are the key features for settling disputes without going to court, or in supply chain context, more likely going to arbitration. But in this kind of very loosely knit, geographically scattered, highly asymmetric group, how effective could information sharing and reputational costs really be? And second, the shadow of law is not as long and as comforting in transnational contexts. And I want to be clear here what I mean by this. So contract and commercial law literatures that touches on supply chain, at least in the US, often dismiss the legal system of host states as inadequate, going so far as saying that they are dysfunctional. I suspect many of us would find this view incomplete. Certainly in areas like human rights, ramification of supply chains, a lot more work desperately needs to be done. That said, formal adjudication is one normative tool in the dispute resolution toolkit in transnational contexts. And in host states, the informal cost of using law is high, not just in the extra legal costs that might incur through rent and corruption, but also the cost of severing the relationship. So how does relational contract function in a world where the shadow of the law is short, or at the very least uncertain? Well, my preliminary findings suggest that the above features are a real concern and are somewhat mitigated, or at least attempted to be mitigated by an additional actors to this contracting war, the local authorities, but only when the parties are unable to overcome these barriers themselves. So there is a long and rich literature in law and society and comparative law in Asia about authoritarian states and the preoccupation with stability, the most threatening of which is collective action. So for example, when a Taiwanese shoe manufacturer in Vietnam almost went bankrupt due to COVID and need to close down its factory, negotiation broke down. The local authorities then stepped in, the provincial bureaucrats, to broker a deal between the company and devastated workers, helping the workers get higher severance pay and rechanneling the company to become a subcontractor for another garment supplier that has successfully pivoted to making masks. So relational contract theory, I found so far, is highly relevant, highly potent in supply chain contexts, especially with renegotiation triggered by the pandemic. But it isn't just an arrangement by the parties to go off the contract and be informal. It's no longer that. It also takes on a public dimension through the entrepreneurial efforts of local bureaucrats to mediate disputes, albeit in a very ad hoc basis. Now, this helpful attitude is not always welcome. In fact, some interlocutors have confided that they really do not want local authorities to get involved because, of course, that incur informal costs that they have to pay. This desire to avoid local authorities, perhaps ironically, also push parties toward dispute resolution. So now what about the formal contract? What about those force majeure clauses that lawyers around the world are probably, as we speak, spend their wild and precious life drafting? Are they completely irrelevant? Well, not quite. So no one I spoke with so far has said that they looked to the original formal contract to see if it could be enforceable, just completely unrealistic. One person said, who could wait 10 years to figure this out? But the original contract does play some roles in renegotiation, albeit a soft referencing role. One person said it acts as evidence of her good faith when she originally negotiated the contract, and therefore also evidence that she will continue to act in good faith going forward. So this is precisely the information signaling function that rating theorists told us, although it is now happening post-breach rather than in the ex-ante of rating theory. And this signaling function can play a critical role in an environment of high uncertainty and distress. So I will conclude. As I said, this is a very early work. I'm still in the process of interviewing, trying to refine the thesis. I look forward to any suggestions you might have. And of course, if you know any supplier, relevant people, since we're all around the world that may want to talk to me, please let me know. Thank you very much.
Thank you, Tran. So we don't have much time, but why don't we at least, raise our questions so that it can help our colleagues to improve their work. Anyone would like to ask a question and you can address it directly.
I have one question for the RPT, related party transaction topic. I want to ask, you said that it's a very interesting topic, and you argue that the procedural safeguards contribute to cooperation in the company. So, but to my knowledge, the disinterested shareholders and the disinterested directors, they are often the minority shareholders of their company, and they have conflicts of interest with the controlling shareholders of that company. So these procedural safeguards, do they contribute to cooperation between the different shareholders, or do they contribute to the check and balance? It's a kind of monitoring the controlling shareholder. You evaluated the different models of the UK, Italy, and the United States. I found that the United Kingdom and Italy, they adopted half of the United States procedural safeguards. One is for the independent shareholders approval. Another, Italy, is for the independent directors approval. Do they have any differences, these two kinds of safeguards, procedural safeguards? That's my question. Thank you.
Just a clarification, between Italy, UK, or between Italy, UK, and the US?
You have 4 or 5 models. So you say some of them with France and Germany have the same value, or so they are all also different. They are different. For example, the Italy and the United Kingdom, they have different approaches for the procedural safeguards.
I guess your connection was not very good, so I lost some parts of the second questions, but I tried to answer the first question. You are right. Some procedural safeguards may fail to create cooperation, and I try to emphasize that by saying that the effect of the procedural safeguard in that regard will depend how effective and arm's length bargaining environment it creates. So if all of the directors of the company are beholden to the controlling shareholder, so the controlling shareholder is the other side of the transaction. If they are beholden to that controlling shareholder and do not actually look for the company's interest, but rather look for the controlling shareholder interest, then they will not create a strong cooperative environment. Rather, they will help the controlling shareholder to divert company value. So there need to be strong procedural safeguards that actually work, that are actually effective. So I do not suggest that lawmakers just adopt strong procedural safeguards without looking how effective they would be. They should also consider how effective they can be, but they also take into consideration the aspect of cooperation, creating cooperation within the company in line with insights from behavioral economics. And as far as I understand your second question, you asked for some differences between different regimes. So in Italy and in Delaware, I think they are more close to each other because there is a more emphasis on independent board committees approval. In the UK, there is the requirement that RPTs, material RPTs, have to be approved by disinterested shareholders. In the US, case law has actually also incentivized some use of disinterested shareholder approval, but it is not mandatory, so we don't see many corporations use it. They don't have to, but in the UK, if you are listed in the London Stock Exchange premium listing, you have to get shareholders' approval before entering into RPT. I hope this helps because I couldn't hear some parts of your question.
Yeah, well, thank you. And let's take one more question from Wendy.
Okay, sorry. So my question is for Trang. I have your observation about how local government authorities have kind of intervened to broker outcomes. I find is fascinating, and I'm just wondering that the participants actually don't like it. Is that a view held by both the international buyer of those goods and also the local supplier? And I wonder is the involvement of the local authorities to broker an outcome, is that occurring at a much greater level than normal? And does that then coincide or reflect just the greatest level of state intervention in the markets in COVID? Because I see that also in other areas of regulation as well. Thank you.
Great, thanks very much for your question. So far, most of the people I've spoken with are local suppliers. So that view is definitely reflected in the local hosts. On the international side, I don't have the actual evidence, but I would guess that they probably feel the same way, probably even more so. And yeah, great point about just the general higher level of state intervention because of COVID. So that's what I need to tease out. Kind of the level of intervention here is quite very detailed, like, into the detail of the contract itself, like brokering, the higher, like one additional month of severance to the workers. And the local authority kind of took the time to talk to the workers, figure out what would appease them, what would make them happy. So yeah, definitely something to tease out more there, but thank you.
Oh, yes. I wish we had more time, guys. I definitely learn a lot personally, and I encourage you continue communication by email if you want. So, and I can be a middle person in this sense. If you have any questions you want to pass along, just contact me and I'll connect you with the, presenter. And it was a pleasure. Enjoy the rest of the conference today, and I hope to see you next year as well. Bye-bye, guys.
Thank you so much. Thanks, everyone. Bye-bye.